Another judge appointed by Donald Trump rebukes Donald Trump's plans to send in the military to Portland, Oregon, finding in essence that it is not a war-ravaged city, but one where the laws could be easily executed. I'm Adam Klasfeld. You're watching All Rise News here on Legal AF, part of the Midas Touch Network. I'm going to read a little bit about the decision late last week by U.S. District Judge Judge Immergut, a Trump appointee who in a 106-page ruling strongly rebukes the Trump administration's view that they can send in the National Guard into Portland under 10 U.S.C. 12406, which can only be invoked when there is either A, an invasion, B, a rebellion, or C, an inability to execute the laws of the United States. Here's what she writes in her ruling, quote, "After analyzing these statutory provisions as applied to the facts of this case, the court arrives at the necessary conclusion that there was neither a rebellion or danger of a rebellion, nor was the president unable with the regular forces to execute the laws of the United States in Oregon when he ordered the federalization and deployment of the National Guard." She added, quote, "This court acknowledges that some citizens may support these deployments as a helpful military supplement to effectuate the president's immigration agenda. But the founders embodied their profound fear and distrust of military power in the Constitution and its amendments, which has lived on through the decades as a traditional and strong resistance of Americans to any military intrusion into civilian affairs," end quote. This Tuesday on Veterans Day, veterans across the country are going to show up to protests under the banner of Veterans Say No. And one of the things that they are saying no to are military deployments like these. Here to break down this and other issues is someone who is an expert on this topic, Professor Jamie Rowen from the University of Massachusetts at Amherst. She is the professor of legal studies and political science there. We've spoken before, and she's an authority on these issues. Thank you, Jamie, for joining.
Thank you. It's a pleasure to be here.
So what was your reaction to seeing Judge Immergut's ruling? It is a lengthy decision, 106 pages. What was your first reaction to the ruling?
Well, my reaction was that it's really wonderful that a Trump nominee is embodying the values of the judiciary, which is that there is a separation of powers in this country and that the judiciary has an important role to play in an area that the executive is claiming more and more authority. What I really liked about the decision, and what I've liked about all the decisions from the district court judges in cases regarding Trump, is that they're very fact-focused. They want to stick to the facts. And one of the things that's really notable is that the story that is coming out of the administration doesn't line up with what judges are finding on the ground. This is not new. This is typical. We saw this in the claims of election fraud in 2020. We saw this in the claims of patriotism in the January 6 riots. But what you see from Trump-appointed judges that care about states' rights is a recognition that this administration, although representing the Republican Party, doesn't embody any of the values that many people who identify as conservatives, particularly states' rights conservatives, value. And so it's refreshing to see a judge do her job.
And you mentioned that she is strong on states' rights. One of the grounds by which she rejects Trump's claim to be able to use the National Guard in Portland is under the 10th Amendment. Can you speak to some of her analysis on that point?
So there were 5 issues that the court was deciding on whether Trump could deploy troops to Oregon, and it didn't have to go much further than the constitutional questions. The other issues are statutory. So this posse comitatus law that people may have heard about around when you can use the military. The grounds for when you can use the military in that Title 10 issue are when there's danger of rebellion and when the president fails to be able to execute the laws, when the president is specifically unable to execute the laws. And what happens when you're dealing with a statute is the judge is trying to interpret the statute. What did Congress intend by using those words? And when you do statutory interpretation, if you are an originalist, like this judge is you look at what was the original meaning of those words at the founding. And so she goes through a good historical analysis of what the founders were worried about when an executive would deploy the military, and that the founders were particularly worried about having standing armies. And so they gave power to states to regulate their militias and gave a very limited power to the federal government to what they call federalize those state militias, basically bring them under the control of the Department of Defense and under the executive branch of the federal government in order to engage in law enforcement activities. The founders were very clear they did not want that. What the 10th Amendment says is if the Constitution does not grant a specific power to the federal government, then that power lay with the states. And in particular, policing power is at the state level. Almost all crimes that we see across this country are prosecuted at the state level because that is in the purview of the states. This country was founded as to be a federation, basically, of states. Again, that fell apart a bit over history with concerns of the Articles of Confederation and then the Civil War, and we wanted a stronger federal government, but still embedded in the Constitution. Really, the only way to get states to ratify the Constitution was to give them power over policing as a fundamental right to protect them from encroachment by the federal government.
You mentioned that Judge Immergut is an originalist, that she is apparently a Federalist Society member, very movement conservative, staunchly conservative judge, and she reached this outcome based on those values. Can you talk a little bit more about that?
Yeah, so if you are a member of a branch of judicial thought that looks at what the original text of a statute means, trying not to think so much about the policy implications, but what did the people who wrote the law want it to do, this case is clear. And so in her decision, she walks through when and under what conditions the federal government can federalize the state militias. And in particular, she's interested in this idea that is in that Title 10 statute, which basically gives the executive branch the power to federalize the state militias. She looks at the third prong of that statute, which says that the federal government can federalize the state level militias if they are unable to execute the laws. And what she says is unable to execute the laws isn't it's a little harder, it's we cannot do it. In fact, she points to two examples of rebellion in which the federal government federalized those state militias, the very famous one that people have heard of, maybe the Whiskey Rebellion at the end of the 1700s, and said that it was actually that level of rebellion when the federal government said we cannot execute the law. They actually said, they didn't use the word rebellion. They said, we need the militias to be federalized because we cannot execute the law. So that is the level of inability to do your job. Now, what she points to is that the Ninth Circuit, which is the appeals court that she is under in Oregon, said in another case called Newsom that if there is minimal interference with the execution of the laws, then the state militias can't be federalized. There has to be a significant impediment to the execution of the laws. And so her entire decision is going through the facts of the case and showing that there was minimal interference, using the language of the Newsom case to say this is minimal interference. And one of the reasons that she's making that claim is that the minimal interference occurred in June of 2025 when there were some acts of violence against federal officers. But Trump did not call the National Guard to Oregon until September. And between June and September, there were few, if any, incidents of violence. And she says timing matters, that when you look at this law, you cannot claim that there was incidents of violence and we were unable to execute the laws 3 months ago, because there's a slippery slope. would Trump be able to bring in the National Guard because of violence in 2020? Right, which is one of the things that he's been commenting on since 2020. And so she's pointing to our concern that we're not looking at the facts on the ground when we're claiming inability to execute the laws, and that the founders of the country wanted that. They wanted it to be that regular civilian law enforcement is overwhelmed and needs military force. If regular civilian law enforcement is not overwhelmed, rely on the civilian law enforcement, because the founders of this country were terrified of a standing army and what it would do to individual liberties if they did not submit to the civilian law enforcement.
And we've seen in prior orders the police reports from the 5 days leading up to Trump's declaration and federalization of the National Guard. And those police reports said that there were no incidents. That I think the day before the federalization order, the police report said that the energy was low at the protests and zero incidents. I want to talk about one relatively short passage of this 106-page ruling where Judge Immergut entirely debunks what the Trump administration has been saying about Antifa on the ground in Portland. She looked at the evidence of that after a trial and found there was nothing there. Can you speak about that?
Yeah, I think what impresses me about this decision is it's almost like Immergut is speaking to the Fox News audiences that are claiming that these protests are organized in some way. She actually devotes several pages of the decision to debunking the entire thesis that these protests are organized. She says they're basically not. They're people showing up to protest. She points to the costumes, which a lot of people have been paying attention to. And in one line of that, she refers to Antifa and says, this is not an organized group. It's maybe an ideology. It's something that's called anti-fascist. And maybe 5 years ago, there was an organized group of people who identified as some type of organized Antifa, but that none of the police officers that are on the ground can say that there's anything that looks like an organized group of people that are orchestrating these protests. And again, if you're thinking about the word rebellion, which is what the Trump administration is relying on to suggest we need the National Guard, then you would want to have some type of organization to say that the military is needed. But the officers on the ground repeatedly say there's no evidence, and Antifa is just a word that is being thrown around by the Trump administration, I think, to scare his base and make it look like there's some reason to be deploying the military when this judge finds there isn't.
And I want to unpack the significance of that a little bit more. Of course, Donald Trump issued an executive order proclaiming that Antifa is a so-called domestic terror organization, even though there is no such concept under U.S. law. And here is a Trump-appointed judge finding through a trial and testimony by local law enforcement that not only are they not creating havoc on the ground in Portland, but correct me if I'm wrong, she is saying outright, based on the testimony of law enforcement witnessing everything that's going on, there is no such thing as Antifa in Portland.
She's saying that Antifa might be an ideology, but it is not an organization. And that's a really important distinction when we think about the Red Scare in the United States, right? People can be afraid of ideologies such as communism. But what they're really scared of is that there's an organized group of people committed to that ideology that might engage in violence. And that is the lie that has been repeated in a lot of right-wing media that Trump is using to make claims that he needs to deploy the National Guard. And this judge, with the testimony of a police officer, debunks it completely.
I want to shift gears a little bit about the upcoming protests on Veterans Day. It's VETS Say No, and part of what they're saying no to, as I said in the introduction, is military deployments like these in American cities. You've spoken to a lot of veterans. You stay on top of veterans affairs, veterans' rights. What have veterans been saying about the deployments that Trump is seeking in places like Portland, Los Angeles and Chicago. He's only been able to carry it out so far in Washington, D.C. and L.A.
The veterans that I have been speaking to, and as well as family members of active duty military, are very upset about this. And they're saying a couple of things. The first is they're saying this is not what we're trained to do. And you may have heard this, that one of the reasons we do not want the military engaging in domestic law enforcement is that the military is trained to see people as enemies, and they are using mainly international law that has been domesticated to talk about how to treat civilians versus militants, and to not disproportionately hurt civilians and to actually treat with some humanity the militants. They're not trained in constitutional rights. They are not trained in any domestic law enforcement that has to think about Fourth Amendment search and seizure protections, Fifth Amendment due process protections. And so they don't know what they're doing, actually, when they're being asked to engage in what they think of as domestic law enforcement. They're also concerned because, look, immigration enforcement's immigration enforcement. That's within the Department of Homeland Security. ICE has arrest powers. They're doing their job under the Department of Homeland Security. But the Department of Defense sees themselves as protecting the homeland from foreign invasions or protecting U.S. interests abroad. So their entire job has not been engaging in deporting undocumented immigrants. And so this isn't what they signed up to do, and they're being asked to do it. In addition, people in the National Guard, we have to understand, are our neighbors. These are people who signed up to join the state militia. The origins of the National Guard are the militias that are actually regulated by Article 1 of the Constitution that say Congress regulates them. Congress gave the power to the states. The states are supposed to be in charge. You're supposed to be helping out the states. And so the people who are in the National Guard, especially in the reserves, have jobs. They have families. They're in community. To ask them to leave their families, leave their communities, and leave their jobs for this kind of enforcement activity when it's not clear they're needed, when they signed up to be of service, feels insulting to them, and it harms their families. And so they're not happy about this. They don't think it's right. And they're very concerned because their chain of command, the way it works in the military, is you do what you're ordered to do. And so if you don't necessarily trust that your leader at the Department of Defense or your executive is actually following the law or has your best interests or the community's best interests at heart, it puts you in a really bad situation where your training is to follow orders, but you're questioning those orders. And so veterans are watching this, and I've heard them literally say, this is insulting the service. This is insulting what I signed up to do. I'm terribly worried for these families. Then on top of that, we have a government shutdown where people are not getting the benefits that they deserve. The vets say no are mainly post-2001 vets. And these are people who are trying to get their GI Bill benefits for education that can't actually access their benefits because even though most of the VA workers are exempt from the shutdown, there are still closures at the agencies that are providing the benefits for veterans, and they're livid. They're absolutely livid. They're having to pay tuition, but they're not able to get their tuition benefits from the federal government. Active duty abroad may be getting paychecks, but it's not clear food is getting to the bases. And so you have this whole conundrum where people who are active duty or veterans are watching the government that they signed up to protect and defend not protect and defend them.
And on top of all of that, there is a federal law, Posse Comitatus Act, guarding against the use of the military for civilian law enforcement in most instances. I want to end on one quick note. A lot of the enforcement that we've seen, especially in terms of immigration enforcement across the country, has been by federal agents who are dressed as if they are members of the military, but are not, in fact, members of the military. We're seeing ICE dressed up in militarized gear, or Border Patrol, or other agencies. One of the things that I've seen in legal briefs from military members and veterans who oppose this is the image of a nonpartisan military, a nonpartisan National Guard. Has that come up in the conversations where folks might worry about the deliberate sowing of confusion as to who's carrying out some of these viral abuses of power that become videos that go across the internet?
This is absolutely of concern. People who were in the military are proud of joining the military. Many of the veterans I speak to are Vietnam veterans who actually feel terrible about their service in Vietnam and are still reckoning with what they call moral injury from it. And they're worried that what you're going to see in these younger active duty military men engaging in these types of enforcement is a similar moral injury, where they're going to feel that they were participating in something that was wrong and immoral. And that's going to affect their sense of self moving forward, which has definitely harmed at a very deep level many of the people who participated in wars that they don't believe in. Then you also have others that I've heard say that we think young people should be joining the military more. We actually really appreciate the opportunity to have gone to the military and get the type of training. And there's going to be a lot of difficulty recruiting young people to join the military if the young people are seeing images of the military engaging in actions that they think are unlawful, if not immoral. And so I have definitely heard concerns about this. It's something that people in the military, that if you're not familiar with veterans or people in the military, there is a culture and a pride about the work that they've done and did. And it's insulting to see themselves being used as pawns in policies that they're not trained for, that they don't believe in, and that can be really harmful for due process in this country.
Thank you very much, Professor Rowen, for breaking it down. For folks who want to find out more about this case and other cases that we report on, visit www.allrisenews.com. That's www.allrisenews.com. And to watch other videos like these, subscribe now on Legal AF.
Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.